Hello, everyone, and thanks so much for joining us. This is part of Venable's Advertising Law monthly webinar series, but today our focus is privacy. Our program today is going to be divided into three parts. First, a quick update on U.S. state privacy laws. For anyone that's been following this area, you know that state privacy laws are incredibly dynamic right now, and there are a number of updates just from the past few months. We could spend more than an hour on the legal updates, but instead we're going to provide you with the Cliff Notes version of a state law update. Then we're going to talk about privacy assessments, a set of effective, tailored tools that can help your organization at one end determine baseline legal requirements, or on the other end, holistically assess the privacy practices of your organization in order to build or mature your privacy program. And then we're going to end with a fun little exercise to put it all into practice. It's the slide. My name is Kelly DeMarcus Bastide. I'm the co-chair of Venable's Privacy and Data Security Group, and I'm joined today by two of my Venable colleagues. Jamie?
Hi, good afternoon, everyone. I'm Jamie Danker. I'm a Senior Director of Cybersecurity and Privacy Services here at Venable. I'm part of the Cybersecurity Risk Management practice, which is we're non-legal professionals that work side by side with our legal colleagues.
And hi, everyone. I'm Ivy Orecchio. I also work in the Cybersecurity and Privacy Services Group as a project manager here at Venable. Thanks for joining us today.
Thanks. So let's dive right in. If privacy is not part of your primary responsibilities, you may be aware that things are changing rapidly, but maybe not aware of the full scope of the changes. So here is what our state privacy law map looked like just 1 year ago. There are 5 states with omnibus privacy laws, plus Nevada, which is a little unique. And in fact, this is actually where we are today if you're just looking at laws that are active and currently in effect, omnibus privacy laws. And here is what the map looks like now. At present count, we're at 19 state laws. Another tranche will come into effect starting July 1 of this year, and then roughly twice a year, additional state laws will come online. Most recent developments were in Minnesota and Vermont. They've passed privacy legislation, and those bills await signage by their respective governors. That's why there's an asterisk on those states. So TBD, especially Vermont, where there is actually some uncertainty as to whether the governor will sign. The remainder of the laws have been passed, they've been signed, and they will come into effect sometime over the next 2 or so years. Okay, so when are all these laws coming into effect? This is where we are today again. So if your organization processes sufficient quantities of personal data to trigger privacy laws in all states where a law is active, this is the schedule upon which you've had to come into compliance with these state laws. The law that most recently went into effect was Utah at the end of last year. And here's where we're going. So this is what the timeline is going to look like going forward. As you can see, in 2024 on July 1, we have Florida, Texas, and Oregon coming to effect, Montana on October 1st. That'll round out 2024, and the rest of the laws that have been passed to date will come online largely in 2025, early 2026. As you can see, privacy laws tend to come into effect sometime around the beginning of the year, around January 1st, and then typically around mid-year, around the July timeframe, with the odd October state sort of tucked in there. This timeline and the map are only gonna, we're gonna keep coloring states in, I'm afraid. So just omnibus privacy laws at a glance. We obviously don't have time to summarize the unique aspects of each law, and you would be pretty bored if I sort of walk through that this afternoon. But I think the thing to understand is that the laws remain to date similar enough so that organizations can chart a single compliance path, but there are unique differences starting to emerge within the state law. This slide compares states through New Hampshire. We frankly couldn't fit now all 19 active states on a single slide. And you'll see here that California, Nevada, and Utah are the outliers of the states that are currently in effect. Utah is a little lighter than the other state laws. We also have added Nevada here. It doesn't typically get grouped in with the other laws because it's far narrower. It applies to a narrower subset of personal data, and it doesn't have the full complement of rights that other laws feature. But we do consider it an omnibus privacy law because it's not specific to any industry. California, of course, was the first, and it remains unique in many ways, including its treatment of pseudonymized data, and the fact that it applies both to business contact information and to employee HR data. So still remains unique in those aspects. All the laws are similar in the sense that they all include notice provisions. They are all premised on consumer rights. They all have sensitive data definitions. The scope of those rights, how they have to be implemented by the organization, that's where we're starting to see some changes. Important to notice that none of the laws yet have a private right of action. They're all regulatory enforcement. We'll talk a little more about that. But Vermont is going to upset the apple cart if it's signed. It has a limited private right of action. So we're really in a place where it's like a photocopy of a photocopy, where it starts to diverge from the initial pattern, and each state law introduces one or two additional changes going forward. Okay, so moving to the next slides. Again, we're not going to do a blow-by-blow recap of the states, but we wanted to give you a couple top-line takeaways. California remains the most has the broadest coverage because of its coverage of personal and B2B data, and no exemptions for pseudonymized data. They also have a universal opt-out for sharing. That's defined as data use is tied to targeted advertising, but not mere disclosure or processing. California and Colorado also have very detailed regulations. So this points to active regulators in those states with an interest in enforcement. Some of the laws are more limited in scope. We talked about Nevada. Florida only applies kind of to the tech titans, except it does have a narrower set of provisions that apply to sensitive data, and those apply to all companies. And Texas exempts pseudonymized data fully unless it's tied to identifiable data. So we have a lot of laws kind of following a common pattern with variations on the theme. States are also passing special issue privacy laws tied to health and kids data, and we'll talk a little more about that in a moment. So we don't have time to go through the state laws very closely today, and unfortunately you'll have to work through that on your own. But when it comes to the question of what should we do next, we did want to offer a few next steps. As we mentioned, you're looking for updates roughly twice a year if the current cadence holds. And those are opportunities to look at your privacy policy, your contract clauses. A number of these laws have specific provisions that have to be in your contracts with service providers or data processors that are processing data on your behalf. How you implement consumer rights and your approach to sensitive data to validate whether the approach that you're using now will extend to whatever group of states is coming online. Just looking ahead in 2024 for the 4 states that we're looking at this year, significant changes are not needed to address those 2024 and 2025 states. So that trend seems to be holding for now. But, Vermont is one state that might add a wrinkle there. And who knows whether other states are going to look to move legislation this year. At a very minimum, the CCPA in California has statistical reporting requirements, and those have to be updated annually. So at a minimum, you will have one privacy policy change that has to be made. Another aspect of these laws, many of them require data protection assessments, and we're going to be spending a lot of time today talking about assessments. But a lot of the laws have formal triggers where you're actually legally required to conduct assessments. That could be for targeted advertising, if you're engaged in the sale of data, or if you're processing sensitive data. And that's another thing that you should look to update, twice a year. You could probably rely on assessments that you've done for state law compliance in the past, but they might need to be refreshed or updated or, added onto to address new state law requirements. And something that just with the kind of volume of changes and the speed of these changes, a number of the companies we work with really have privacy working group sessions, which are an opportunity to stay proactive and to understand how the business wants to comply with these laws. When there were only a small number of them, it was easy enough to say, oh, well, we'll just follow the laws in those states and carve out the others. Now that we're getting somewhere close to about half of the US states having some kind of privacy law, if they have a material impact on your business, you may want to continue to follow that state by state approach, or you may have reached a tipping point where following a uniform national approach is simpler for your business. Those are the kinds of issues that you can really air in these kinds of privacy working group sessions. Okay, so just to focus a little more on what's going to be happening for the rest of this year, we have a big update on July 1st with Florida, Oregon, and Texas. And we wanted to just pick out a couple things that were unique about these laws to the extent that you're getting ready to add them onto your existing compliance posture. Texas applies very broadly to any business that doesn't qualify as a quote unquote small business. And there's actually some analysis that needs to be done when it comes to the number of personnel that you have and kind of the volume of your business. So most of these laws are tied to data processing volume. Texas actually looks at the size of your company itself. Oregon uniquely applies to nonprofits. Colorado already applies to nonprofits. Others coming into effect in the future will, but Oregon is the one that will hit as of July 1st. And Florida, as I said, most businesses are carved out of kind of the broad consumer rights provisions of Florida, but they do have sensitive data requirements that apply to any business that's sort of collecting personal data that's deemed as sensitive. And then October 1st, we have Montana coming online. Montana notably has a lower threshold. Most states apply when you're processing data of 100,000 or more state residents. Montana, being a smaller state, puts that at 50,000. A couple things that are odd about this crop of 2024 states. Oregon has now a right to get a list of specific third parties to whom your data was disclosed. This is by name. So other states have this by category to say, oh yeah, your data was given to service providers and data brokers and, partners in the market. Oregon, you actually have to say company A, company B, company C. So that's a bit of a heavy lift if you get those types of requests from Oregon residents. And one we're seeing really being limited to Oregon. This is not a place where companies are taking a uniform approach nationwide. Oregon also has some new categories of sensitive data that are not replicated in other states. These include national origin, status as transgender or non-binary, and binary, and status as a victim of a crime. So if you're processing that type of information in Oregon, and it includes nonprofits also, so you could be processing it certainly for a beneficial purpose, look closely at the Oregon law because it might apply to you. Florida and Texas require a specific notice in the privacy policy or the homepage if you're processing sensitive data. This is like a block of text that has to go on your homepage that says like, we process sensitive data in all caps. So just a piece of implementation to think about in those states. And Montana and Texas are going to recognize universal opt-out mechanisms for targeted advertising. You have to be applied to your website. That goes into effect January 1 of 2025. Because we're asked a lot about what the enforcement posture looks like in the states, the state omnibus privacy laws still generally provide for regulatory enforcement. I noted that Vermont does have a limited private right of action, but that's sitting on the governor's desk and it may not be signed. So something to keep an eye out. They all have statutory penalties, but they don't allow for class action lawsuits. States other than California typically allow for a cure period, but some of those cure periods are going to sunset in the future. So it's an area where the laws are dynamic and they're going to change of their own accord. But in states that have a cure period, if you get a notice of violation from the state attorney general or the relevant regulator, it will give you 30 days or so to fix the problem. And if you fix it, that's the end of the matter. But like I said, some of those cure periods are going to sunset. Where we've seen enforcement priorities, California has been focusing on consumer complaints and also proactively investigating violations. They like to do sweeps of industries, so send a whole bunch of letters to a number of players in a particular industry and ask them about how they're complying with the CCPA. Most recently, connected vehicles was an area where they were doing a sweep. Connecticut has publicly announced their priorities and what they've done. They have been focusing on privacy policy changes, and they're interested in sensitive data and data broker practices. They have said that they've been sending cure notices and inquiry letters to app developers, grocery stores, genetic testing companies, and car manufacturers. So just a hodgepodge of industries that are of interest right now in Connecticut. And Texas has began enforcing its data broker registry. Texas, along with California and Oregon and Vermont from some time in the past, are states that have requirements for companies defined as data brokers, i.e. data resellers, to register publicly. And Texas has been looking at companies that are registered in other states and sending them a letter and saying, why are you not registered in Texas? So that's been an area of focus by the Texas regulator, even before the law fully goes into effect on July 1st. Okay, so I wanted to take a minute before we move to assessments and just talk about state health data laws. Besides these omnibus privacy laws, the states have focused a lot on specialty laws, more narrowly targeted. A number of states have passed laws related to children's data, to kids, and 3 states have become active when it comes to state health laws. So we have new laws that regulate health data in Washington, Connecticut, and Nevada. And you may say, well, I'm not a covered entity. I've never worried about HIPAA. These laws sweep far more broadly. They define health data differently, but it's some version of data that's linked or reasonably linkable to a consumer and identifies the consumer's past, present, or future physical or mental health status. This can be as simple as someone publicly posting that they're home from work because they have the flu, providing, skincare, preferences, if you sell those kinds of products, saying that, oh, I need help with eczema, raising their hand. We're going to do an example on that's tied to that a little later. But Connecticut and Nevada, these laws sweep more narrowly. They focus on if the data that you're collecting is being used to identify a consumer's health condition or diagnosis. So if you're kind of sorting those consumers based on the data that you're collecting, that they've offered up or via their purchases and sort of extrapolating a health condition, that's going to be covered in Connecticut and Nevada. Washington is broader. And if the health data is coming into your system, it may potentially be covered. Washington is also a special concern because it does have a private right of action, and there's no minimum threshold for data processing in Washington. Sorry, 1 second. I wanted to go back and just do a quick deep dive into Washington. I know there's a lot of text on this slide, and I think you'll get the slides to look at them after, but it's a pretty complicated law. Consumers, you'll have to publish a consumer health data privacy policy if you're processing health data from Washington residents. And consumers have rights to access and deletion, also a requirement to get that list of third parties to whom their data has been shared. There are affirmative opt-in requirements for processing health information in Washington state. So if this is an area where you think you might trip over the law or you might be collecting health information as defined here, it's a place to look very carefully. Data that you're already processing isn't grandfathered in under the law, and there are very robust consent provisions there. So health data laws are a really good segue into the second part of our presentation, where we're going to be looking at privacy assessments, or as we're going to term them, how to examine your organization's privacy health. We're kind of taking the position that a privacy assessment is like that annual checkup that you get from your doctor. Before we sort of talk about what we mean by assessments, a different type of assessment, products and scoping, we wanted to just pause for a moment and talk about why your organization would take the time and resources to undertake a privacy assessment. I hope I've sufficiently scared you around the sheer volume of new U.S. privacy requirements and changes in legal requirements. So at a very baseline level, an assessment can help you look at whether your company or organization is in compliance, whether there are gaps, and gaps, of course, could lead to enforcement and potential fines. But they're also helpful from a compliance perspective, too. These laws are long, they're wide ranging. They have a number of exemptions. You may not be taking advantage of all the exemptions that are available to your organization. So not just gaps in compliance might be identified, but gaps in ways to avail yourself of positive parts in the law that could help preserve parts of your business. So a way to sort of be opportunistic within the scope of these laws. Might also give you a place to look for opportunities to make your practices uniform, which just makes it simpler for your business to comply with kind of this regime of ever-changing requirements. But aside from kind of the legal compliance piece, other reasons to look at privacy assessments, customer trust. Some organizations might really want to use privacy as a competitive differentiator, and an assessment can help you tell your privacy story to your partners, to your customers, to potential customers. If you're able to articulate your compliance strategy and how you're being proactive in privacy, that's certainly something that you could use to your competitive advantage. Also from an innovation perspective. So attention to privacy can help your organization kind of unlock the value of data that you have while staying in compliance with privacy laws. Sometimes because these requirements are so complex and overwhelming, organizations take an overly conservative stance, saying, well, you know what, we're just not going to touch this data, or we're kind of scared or afraid because of potential liability to do more with it than we could. So we've seen organizations use privacy assessments as a way to really unlock that data while building a strong privacy program that keeps you, of course, in compliance with law. And then future proofing. You can see we're just in a cycle of continuous churn with new laws, and it's really exhausting. There's a lot of privacy fatigue out there when you have to kind of dust off the same documents every 3 or 4 months and bump them up against the requirements of yet another law and see if you're in compliance. So it's really easy to get lost in that compliance churn. So taking a more holistic approach to privacy organization-wide can help kind of keep your organization, keep your head above water. If you take things to looking at how your company or organization is tackling privacy holistically. So we will talk about that a bit more. One approach we like to leverage here at Venable is the NIST privacy framework. And with that, I will turn it over to Jamie to kick us off on assessments.
Awesome. Thank you, Kelly. So going with the health theme, we really think that assessments are really your organization's best preventative medicine. So we're going to go over the different types of preventative medicine here, including those that are legally required, and then programmatic assessments, which aren't necessarily required by law, but really can help you with that future proofing of your products and services. And then we will also talk about some of the helpful tools to check the health of your privacy program that will also support your compliance with state data privacy laws. And last, Ivy is going to provide a hypothetical use case to sort of tie it all together. So first, let's talk about the state privacy laws and privacy impact assessments.
Yeah, and I've already touched on this, so I don't need to belabor it, but a number of states have formal requirements or triggers in the law that do require you to assess certain practices. Generally, these might be required when you are engaged in targeted advertising, selling personal data, or processing sensitive data as defined by that state's laws. These assessments are not intended to be static. They're supposed to be a kind of living reflection of that part of your business. So there's something that have to be dusted off and kind of looked at as your business changes and grows. And then, of course, you know, new states are coming along that are going to require you to do this. You probably leverage the ones you did in previous states, but, you know, you want to make sure that you're staying within the bounds of what's required.
Absolutely. And now we're going to talk about programmatic assessments or holistic assessments. But I think it's worth mentioning the Tennessee Information Privacy Act, which is a state privacy law, which specifically references the NIST privacy framework. It's an instance where it isn't legally required, but if you can develop a privacy program that, as the law says, reasonably conforms with the NIST privacy framework, it can provide benefits to your organization. Specifically, here. You are able to claim an affirmative defense against a claim of violation of the Tennessee Information Privacy Act if you have a privacy program that reasonably conforms to the NIST privacy framework. So to qualify for the affirmative defense, you have to create, maintain, and comply with the written privacy program and design the program in reasonable conformity with the NIST privacy framework. We're going to talk about how you might use the NIST privacy framework as an assessment and then be able to demonstrate that you reasonably conform with the privacy framework. And then we have here all the other items within the Tennessee Information Privacy Act, but it also requires you to regularly update your privacy program 1 year after future updates to the NIST privacy framework. And as I speak right now, NIST is in a process to update the NIST privacy framework version 1.0 to version 1.1 will be a minor update. That's going to commence next month. But I've talked a lot about the NIST privacy framework, but I haven't actually explained to you what it is. For those of you who aren't familiar with NIST, it might be the first time you're hearing about the NIST privacy framework. Others, you might know about NIST, but you're unfamiliar with the framework, and want to shed a little bit of light on the framework and focus on the who, what, and why, and some of the examples of how you can leverage the framework to strengthen your organization's privacy posture, regardless of whether you are subject to the Tennessee law. So who is NIST and why the NIST privacy framework? So the National Institute of Standards and Technology is a non-regulatory agency that's part of the Department of Commerce, and they develop cybersecurity standards, guidelines, and best practices that are widely adopted by government and industry. NIST has several popular risk management frameworks, including one which you may already know of, and maybe your colleagues if you have a cybersecurity program are already adopting, called the cybersecurity framework. It's also worth noting that NIST recently issued the AI risk management framework earlier this year. I believe it was in January. So in 2018, NIST launched an effort to build a voluntary privacy framework to support an organization's ability to build innovative products and services while protecting individuals' privacy. So kind of to the slide Kelly was talking about, that ability to unlock data, but also still preserve privacy. Privacy frameworks are designed to be flexible, and it can be used in a variety of ways. So you can reasonably conform to it. You don't have to pick every single thing in the framework and align to it. So at the programmatic level, you can use it to establish a new privacy program or improve an existing one. Some of you may already have an existing privacy function. At a more granular level, you can also use it as you're developing a specific product or service. And then I think of most interest to everyone here on the call is to support compliance activities such as data privacy law compliance when you take care to evaluate your compliance obligations through your governance and risk assessment processes. And both of these are outcomes in the framework. It can also be used as a tool to strengthen accountability, collaboration, and communication within the organization. And last, to build customer trust and establish privacy as a differentiator. Now I'm going to go over some of the mechanics of the NIST privacy framework. This is not going to be an entire session on the framework. We actually have webinars that go into a bit more detail on that you are free to join. So the framework comprises 3 components: core, so almost think of it as core health, profiles, and tiers. And if your organization already uses this cybersecurity framework, it should be a familiar structure, and that was by design. When NIST asked for feedback on the desired attributes of the framework, stakeholders really wanted what was familiar, that familiar structure. So the core is a set of privacy protection activities and outcomes that allows for communicating priorities across an organization from the executive level all the way down to the implementation and operation level. So the core is further divided into categories and subcategories, and those are discrete outcomes for each function. Now, profile represents an organization's current privacy activities or desired outcomes. And to develop that profile, your organization can review all the outcomes and activities of the core to determine which are the most important to focus on and set both a current or an as is, and then a desired profile. Implementation tiers are a point of reference on how an organization views privacy risk and whether you have sufficient processes and resources in place to manage the risk. So tiers reflect a progression. It could be starting from informal reactive responses to approaches that are more agile and risk informed. There are 4 tiers, beginning with tier 1. You got partial. Tier 2 is risk informed. Tier 3 is repeatable. Tier 4 is adaptive. And it's important to note that the highest tier is not the aim of the framework. It really all depends on your organization's unique operating environment, and it may not be practical or advisable to be a 3 or 4 in all cases. So let's talk a little bit more about the NIST privacy framework functions. It consists of 5, which are further broken down into categories and detailed subcategories that describe the programmatic needs, activities, and outcomes. So looking closer at each of the core functions, they articulate sort of the high-level goals. The identify function is the foundation for identifying and managing privacy risk. It includes activities like understanding what data are processed, mapping data flows, conducting privacy risk or privacy impact assessments. The govern function involves the structure, strategies, and values that define how privacy risks are managed and prioritized. This includes assigning roles and responsibilities related to privacy. Could be that you have a chief privacy officer or someone that wears multiple hats, depending on your organization, and establishing organizational priorities and risk tolerances that support decision making. Now, the control function addresses activities to manage data and data processing with enough granularity to manage privacy risk. Kelly talked about some of the state privacy laws and like data subject access requests. So in the control function, you'll see outcomes there that align to what you might need to do to implement a DSAR process. The communicate function is concerned with the internal and external messages and records about data processing activities to support and understand privacy practices. So the goal here is to enable organizations and individuals to have a reliable understanding and engage in a dialogue about how data are processed and associated privacy risks. And the 5th function, protect, is really a shared objective with cybersecurity. It includes developing and implementing appropriate data processing safeguards. So we're not going to go through the entire core. I believe we have some links to the privacy framework where you can download the core and take a look at all the outcomes on your own. But I just wanted to show an example of alignment with the state privacy laws requirements. So here we've got govern, which is developing and implementing the organizational governance structure to enable an ongoing understanding of the organization's risk management priorities that are informed by privacy risks. And so often in privacy programs, policies, processes, and procedures are very important and kind of core to the privacy program. And you'll see this subcategory here, legal, regulatory, and contractual requirements regarding privacy are understood and managed. So that's really where you see kind of the legal tying into the NIST privacy framework. So I just wanted to give you an example of what the results of an assessment could look like using the NIST privacy framework as the basis for assessment. So each function is reviewed and a tier is assigned to establish a current profile. And this is sort of based on each function. So you've got essentially a score for identify, govern, control, communicate, and protect. And on the left is the current profile. And then the target profile is on the right. So you can see this fictitious example here. The organization wants to elevate its profile generally and become at a higher tier as it wants to mature its policies, processes, procedures across all functions. So really approaching the NIST privacy framework as a holistic assessment rather than a checklist of required tasks can have some really empowering results. Assessment findings really can identify both strengths, kind of getting to Kelly's point about unlocking the value of data. You might be very strong in your data governance. There might be opportunities identified there to really unlock the value of that data even further. But often, of course, as an assessment does, you're going to find areas to improve on. And the flexibility of the framework allows for recommendations that truly speak to your organization's unique goals and the goals of its privacy program. Or if you don't have a privacy program, it can really help you set that up. And so I also think a successful assessment should result in a roadmap that will help your program and team grow, mature, and achieve those goals. So we really understand that getting to a target profile doesn't happen overnight and may in fact require a program to attain additional resources in the form of tools, personnel, or both to reach that desired end state. When it comes to the NIST privacy framework, I really enjoy working closely and partnering with clients to anticipate those needs and develop a roadmap that inspires confidence and makes the target profile achievable. But really, the holistic assessment really helps with that inoculation and future proofing for your organization, because many of the outcomes in the framework can really be mapped to these state privacy laws. So imagine doing one assessment and being able to leverage that for your compliance program overall. And I think you'll find that there are many more benefits outside of compliance with laws and regulations, including be able to talk about how your organization adheres to a NIST standard, to the privacy framework, and that can really help build customer trust here. So that's the holistic assessment, which is where we really recommend that organizations start with. But there are also other types of assessments that can help you out. So some helpful tools. I'm going to turn it over to Ivy to talk about some of the other types of assessments that are helpful to keep your privacy program in shape.
So before we move into that, I want to let everyone know the CLE code word is Privacy 2024. So those of you who joined us who are listening out for the CLE code, that once again is Privacy 2024. So starting off with the privacy threshold analysis, I'm sure we have all filled out forms that look a lot like this at the doctor's office. You're providing your background and personal information, checking off potential health issues, and noting any other potential areas of concern in open text fields. A privacy threshold analysis, or PTA, is pretty similar. Think of it as the intake form at your doctor's office, but for your organization's privacy health. This is a high-level evaluation of a process, a system, or a technology that helps identify potential privacy risks and determine whether an additional, more detailed review like a DPIA or a PIA may be necessary. So just like the doctor's intake form, a PTA may not catch every single potential risk or highlight every priority your organization needs to address, but it's a crucial first step in your privacy health checkup. The PTA provides a baseline assessment that can help prioritize further actions and ensure the most critical areas and ensure that they receive the attention that they need. We had a Q&A about templates and what templates we recommend. A PTA is a great example of this. The template we would recommend is something that helps you identify the risks and the priorities that matter most to you, especially when it comes to intake, whatever helps you prioritize what matters most. If that's the highest risk areas in your organizations or the things that you need to take the first look at, we recommend putting that into your PTA so things go into the queue first. Next slide.
Hang on one second, Ivy. There we go.
So we have, Jamie talked a little bit about enterprise-wide tools, but of course you could do more targeted assessments, looking at a specific business unit or function. One question we get a lot about is, well, I don't have a privacy program, but we need to be in compliance with these state laws. Of course, until there's a national federally preemptive law, the market is only going to become more and more cluttered. You can do kind of that state by state assessment. It would look at compliance with state laws and provide a remediation plans. That's probably the kind of product that most of you are familiar with when you think about sort of a baseline privacy assessment. There are also assessments that might apply to your industry. These might be based on specific laws. So if you're collecting data from kids under age 13, you have to apply with federal law called COPPA. You can assess against COPPA or BIPA, which is the Illinois Biometric Privacy Law, if you're collecting biometrics data in Illinois. We also have a number of clients, of course, right now doing consumer health data assessments. So there are more focused and tailored assessments out there, and they would apply if your business is tailored in this way, or if that's an area of potential risk for you.
And then another area where we end up doing a lot of assessments for clients ends up also being on the security side. So if you're a covered entity or a business associate under HIPAA, you often are required to do a security risk assessment. So we do a lot of those as well. But another area that's really great for staying in shape, and I was a former auditor back in the day, testing your procedures yourself or having a third party come in and test your procedures before a regulator comes in and does it for you is a great way to see if you're truly healthy. So it's almost kind of like a stress test. I love this treadmill icon here because that's kind of truly what it is. So you can assess and remediate your potential problems by reviewing your procedures. For example, your DSAR process, going in and making a data subject access request, making sure that it's kind of easy to find, it meets all the requirements for this particular state law, and that you're meeting the timelines that are specified. And response to privacy complaints. There are kind of a number of different things that can be tested. Sometimes we also call this like a secret shopper type of assessment. So we can go in to look at your website and identify potential issues of non-compliance and make recommendations on remediating them. Then Ivy, back to you for other helpful tools.
So this slide shows another piece of the NIST privacy framework, inventory and mapping. And many benefits can stem from completing a data map and keeping it up to date. And a data map is just a visual representation of how an organization collects, uses, stores, and processes personal data. And although it can be used as an opportunity to identify and correct any privacy issues that you see in the moment, this exercise can be a great way to engage with stakeholders in your business and get to know their systems and programs, how they're leveraging data to achieve business goals, and provide them with an opportunity to ask about privacy outside of more formal review processes. And it has some notable benefits. First, you're going to get a better understanding of the systems, programs, and technologies that your organization has through an asset overview with specific insight into each one. You're going to have an improved understanding of data flows, including data sources, internal and external data recipients, and service providers that may handle personal data on your behalf. And you can also leverage the data map to improve other processes. For example, in the event of an incident, the data map could inform the data that's affected, and information about data flows can assist in containment efforts. The data map can also help you identify if you have issues with shadow IT, and it can also help you reduce costs by consolidating the number of vendors that you might be using for a specific purpose. Someone asked about templates for data maps. There's a number of tools in the market, but you can also break out an Excel workbook and do it manually. We're actually going to use we're going to demonstrate a data inventory in our exercise here in just a moment. Jamie and Kelly, thank you so much for all of the valuable information. This is actually part of the exercise. So before we close out, let's pull it all together for the audience and think about some of these tools. Let's imagine how privacy assessments could benefit a fictional skincare company with online retail operations and some brick and mortar stores. So sticking with our wellness theme, we can all use a little self-care sometimes, right? So this fictional skincare company sells products that are specifically formulated for individuals with allergies and other skin conditions that sometimes require input from a medical provider. They sell their products at retail locations in New York, Chicago, Miami, Nashville, Las Vegas, San Francisco, and Seattle. The company has an e-commerce website that allows them to deliver to all 50 states. And they also have a brand website that they use to push out educational content about various skin conditions. This business is doing great, and they have amassed a loyal fan base among people who require hypoallergenic products, and they're really looking to expand in the next few years. The website currently features filters to help people identify specific allergens that are excluded from their products, and the developers are preparing to launch a new feature that will allow a user to either scan their face or upload a photo or a video and receive personalized recommendations for products that will be best for them. So it sounds like they've got some exciting opportunities ahead. Let's start with you, Jamie, on some additional privacy background that we might want to think about.
Well, I naturally would want to go to the framework at least and take a look at, I would start with identify and govern. To look to see which state laws apply. I would consult with legal counsel here to say like what specific requirements are triggered. But Ivy, I think you did a really great job talking about the data map. And here's where I feel like that helpful tool of let's assume you've already done the NIST privacy framework assessment and you know your organization doesn't have a really great handle on the data that you're processing. So I would say that they need to go and construct their data map first, as a first order to identify all the specific data elements. That's going to help them assess their compliance posture currently. And let's say that they have a privacy threshold assessment process already in place. So we want them to go ahead and fill that form out so we can have an idea of what triggers might be hit. So Kelly probably has some ideas here on what triggers have been hit just based on the facts of the fictitious case study. And some of the data would be provided either through the data map or the privacy threshold analysis.
Yeah, that's right. It would be really helpful to have all of that information collected for your outside counsel, because they would be able to look at how much data you're processing, for example, in California, both from visitors to your website and your in-store location, to see if you trigger the CCPA in California. Similarly, in Tennessee, when that law comes online. But because we've done our NIST privacy assessment, we have an affirmative defense and we have a program that's built there. So that's going to serve us really well when Tennessee comes into effect. Ivy mentioned Chicago, and we have to be concerned about the biometrics law in Illinois, which it's highly litigated by class action counsel in Illinois. And I'm going to be concerned about that because of this new face scanning feature. So we're going to want to dig into whether they're actually collecting biometrics. Are they going to reside on the device? Understanding how that, presumably that's all captured in our data map and in our assessment. Just some thoughts, some initial places to start.
So going through their privacy checkup, we would have suggested that they conduct PTAs and PIAs to understand the privacy risks of each system and website, that they conduct a data mapping exercise, and they keep that data map up to date to better understand how the data moves into and out of and through their organization. And moving to the next slide. After our company conducted their data mapping exercise, they were able to compile their data map into a data inventory. This can be very useful because a data map not only allows you to gain an understanding of individual systems, their data, their purpose for collection and use, how they're collected, used, stored, and shared, but you can take each system and the data elements within each system and compile them into a comprehensive data inventory to get an overall picture of the data that your organization is using. So our organization identified 5 systems and 2 websites. So looking at this layout, we've got the system names over on the left. We're using those gray columns up at the top to identify high-level data categories and the white columns to identify individual data elements within those categories. To drill down. So we can see that they're collecting a lot of basic personal identifiers like name, email, phone, and address. And other categories include online identifiers, financial information, demographics, health information, and commercial information, like records of products purchased, as well as internet activity, biometric information, audio and visual data, and other types of data that's linked or linkable to individuals. So from the benefits that we discussed on the earlier slide, you can think of some immediate benefits from a data inventory. You can probably look at this and identify some clusters of those whys, meaning, yes, they collect this type of information. This might suggest that they have a high volume of those personal identifiers. But you can also identify high areas of risk that might require a call to legal counsel, like the involvement of health information or biometric information. Remember that roadmap about the website, the new facial scanning or image scanning technology that they're involving for those recommendations for health products and skincare products? That might require a call to our friend Kelly. You can go to the next slide.
Yeah, so the third bullet here is to talk to legal counsel. I wish we had a simpler solution, but it's a much more streamlined process. If you can give your legal counsel that data map, it gives them an overview of what you're doing, and it allows us to issue spot in a really efficient and effective way. I think without that kind of tool in your back pocket, you know, it's a series of emails back and forth, and we're sort of trying to hash out the use case. And, you know, maybe that's not as an efficient way to go about this. You know, Ivy called out health data. That's the first thing I would have zeroed in on when I saw that data map. And then layering on the new use, it would have allowed me really to provide a quick gap checklist of things that we need to check or look at before launching the new feature. Also helpful to know, you know, where we might need additional compliance under state laws too. So we have lots of resources available. I think we have some questions. It looks like we have a couple minutes left. So let's see. Sorry, just give us a moment to sort of flip through some of the questions. Okay, so there's a question on the state laws. Somebody asked, do all states currently have an exemption for entities governed by Graham, Leach, Bliley? And are they exemptions from the entire law or some substantive requirements? This is where our landscape is getting complicated because it's a bit of a state by state answer. I think most states have an exemption for data that's governed by GLBA, but it's some states it's kind of applies to the entity, and in other states it's just the data that's governed by GLBA. So I think that's one of the exemptions where it's not possible to chart a uniform path across the states. Okay. Someone asked about the definition of health data in the new state health data laws. The question is, what about asking if someone is preparing their home for something, for example, a baby? Is that technically medical information because you could be preparing your home for a baby and not be pregnant? For example, if you're adopting a baby. So this is one of the kind of complicated hypotheticals that emerges out of these state laws, where the answer is going to depend a lot on how you're using that information. So if you have purchase information from someone that's buying all the things you need for a nursery, like a crib and diapers and all of that, if you classify that consumer as potentially pregnant, then yeah, you've now implicated health data laws because you've sort of tied them to a medical diagnosis or status. If you classify that consumer as, interested in shopping for infants, then probably not. So it's really a place where you have to dig into how your organization is using information to think through whether these laws apply or not. And then related, someone asks, what's the scope of applicability of these laws? Do they apply just to companies formed or doing business in one of these states? And if more broadly applicable, how are companies expected to comply with conflicting requirements? So all of the state omnibus privacy laws have thresholds typically tied to data volume. Some states are unique. For example, California has a separate threshold if you do $25 million of revenue, not specific to California, kind of full stop. And there are other states that kind of take that approach, but most commonly it's data volume. That's intended to exempt out small businesses, but you could certainly be a small business that still processes a significant amount of data. So you're going to have to look at those triggers in the states. They do also, usually apply if you're doing business in those states or collecting data of the state's consumers. Do you have an answer to this one?
So someone is interested in resources or additional training on training or certification recommendations to learn more about data privacy. So like I'm a huge NIST fan. What I forgot to mention is that in my over 20 years of cybersecurity and privacy experience, I was at Department of Homeland Security for 15 years, and I worked directly with NIST and am an author of some of their privacy related guidance, including digital identity guidelines. And I actually helped write the NIST privacy framework. Go to www.nist.gov/privacy framework. And there are a ton of resources available there on the privacy framework. There's kind of a 101 video there. You could also obviously go to International Association of Privacy Professionals, has a lot of information on training and different types of certification out there. The security route is different. There's ISC squared, which is the cybersecurity certification organization, is also a great resource for that.
Cool. Okay. I think we have time for one or two more. So somebody asked if a site has a public facing comment section and someone writes, "This site makes me sick," are they now processing health data under Washington's rule? It's a good one. I think that's one where you could probably reasonably take the position that they are not literally expressing a medical condition and it doesn't fall under Washington. But, you know, if your site is I don't know, a food distributor and it's like, these prawns that I bought made me sick, I was throwing up for 3 days. Now you may be covered by Washington again, if you're collecting that information and how you're bringing it in. So just to show kind of the breadth of some of the hypotheticals under these laws, there's a lot that's unknown because they're so new.
Yeah, and then the question on, do you have a template you recommend for assessments? You know, kind of our view is that the NIST privacy framework itself and the core is a great template for assessments. We provide this service to clients. We've done this several times now, where we use the NIST privacy framework core to develop a set of questions that we go through with organizations. We have workshops, we review documentation, and then we come back with an output of a report with a current profile, a target profile, and then recommendations, and then sometimes even going the next step to helping the organization develop a roadmap to get to that desired future states.
And this makes those functions publicly available.
Oh yeah, all of the NIST resources are freely available. You can download the core in PDF, Excel, and Microsoft Word.
Okay, someone asked a question about nonprofits and the scope of the pending Minnesota privacy law. And there are some unique things about the nonprofits tied to insurance fraud. This is like a formulation we've seen in some other states that have these kind of partial nonprofit exemptions. So unfortunately, one we have to dig into a little more. It doesn't have an easy answer. And then someone asked about summaries for each state's law. We, you know, Venable has some newsletters and digests where we provide information about the state laws, and there are certainly some comprehensive resources available. Okay, I think that's it. I think we've reached the end of the questions.
Thank you so much, everybody.
Thanks for your attention. Have a great day.